Okay, welcome back to part 2 of assignment number 3. See, we left off, we finished problem 40, so we're on problem 41, and this one deals with an automobile and the creation of a security interest in and the perfection of an automobile. And, well, let me look at the facts here. Daniel Huron loaned Jennifer Ontario money to buy a car, and they agreed over the phone that the car would be collateral for the debt. Okay, so they have an oral security agreement. And after that, Huron sent a form to the Registry of Motor Vehicles, and he was listed as a creditor on the car's certificate of title. Does he have a security interest in the car? That's the question. So we're talking about attachment here, but I'll tell you a little bit about perfecting a security interest in an automobile as well. Well, with respect to attachment, the same rule applies. Was there value given? In this case, yes, he gave him the loan. Does the debtor have rights in the collateral? Yes. Jennifer Ontario bought a car, has the car. Was a security agreement authenticated? That means, was it signed? No, all they have was an oral security agreement, and that's not sufficient unless a court believes that just sending a form to the Registry of Motor Vehicles or the BMV or the DMV, whatever it is in your state, just sending a form registering the security interest on the certificate of title, if that's sufficient. And you're directed to 2 cases here, and one of them says in Florida that it isn't sufficient, and I think that's the majority rule. It's just sending a form is not a security agreement. But there's another case in Illinois where it says it is. So it's dependent on state law. This is a gray area of the law, but the general rule for us will be you need to sign a security agreement, and that's a good practice. It's a good practice pointer. You don't want to venture into these gray areas. You want to be on firm footing, and so have a separate security agreement granting a security interest in the automobile, and then you'll be sure that your security interest will attach. And that addresses attachment, and I'll just tell you a little bit about perfection, and this will come up probably later in the book as well. But if Daniel wanted to perfect his security interest in the automobile, the typical way to do that, and the way to do that here in Ohio, is to have the security interest indicated on the certificate of title. So you have the certificate of title that shows the ownership of the car, but on there it will say security interest granted to Daniel Huron. And that is sufficient to perfect the security interest in an automobile, which is a unique way to perfect a security interest. Typically, you file a financing statement or take possession or control, but when it comes to vehicles subject to the certificate of title laws, then it's typically to have the security interest indicated, noted on the certificate of title. So that is problem 41 in automobiles. 42. Okay, now we're talking about promissory notes, which are, in the parlance of Article 9, what type of collateral? Instruments. So we're talking about instruments here, and the facts are that Acro Incorporated owed considerable funds to its bank, and the bank subsequently obtained possession of valuable promissory notes belonging to Acro. So Acro was owed money by someone, and it was documented in the form of a promissory note, and the bank got possession of these, okay, and put them in their vaults. And because the transactions were closed in the bank's offices, the notes were in the bank's vault. Did the notes become collateral for Acro's debt to the bank? Look, this is a pretty straightforward. I mean, promissory notes are instruments. How do you perfect a security? How do you create a security interest in a promissory note and an instrument? How do you perfect it? The same rules apply. You need an authenticated security agreement. You need value given, and you need the debtor's rights in the collateral. Here, the debtor, had rights in the collateral. That's fine. Acro owned the promissory notes, but there wasn't a security agreement. There was value given. I guess Acro owned money to the banks, but there's no security agreement granting the bank a security interest in these notes. So just because they have them doesn't mean there's a security interest that's attached. Now, all that would be required in order for a security interest to attach to these notes and for their perfection would be for there to be some oral agreement, an understanding that's been reached between the bank and Acro that these promissory notes are to be held as security. Because if there's that oral agreement, then there is no authenticated security agreement required. If you have, because there's possession here, they have possession of those notes. If you have possession of instruments, then an oral security agreement will do. And then the possession also perfects the security interest in the promissory notes, because instruments are one of the items, one of the types of collateral that can be perfected by possession. And where is that? I made a note here, 9.3.12a, that instruments can be perfected by possession. So if you're in possession of something, this is the bottom line, if you're in possession of a type of collateral that can be perfected by possession, then all you need is an oral security agreement. And if you have that, you've got attachment, and you've got perfection as well, if you have that possession. Okay, those are all the problems for this assignment. There's this one last case in Ray Howell Enterprises, which is just another morass of messy transactional planning that eventually turns into legal confusion. And the facts are that there are these two rice companies that sell rice, Tradex and Howell Enterprises. And then there's a buyer, Bar Schwartz. But Bar Schwartz wants to pay with a letter of credit. And a letter of credit is this commercial payment device where the buyer promises to pay the seller as soon as the goods are delivered or delivered to the carrier. As soon as you can prove that the goods were delivered to the carrier, then the bank will pay you your money, a letter of credit. But anyway, Howell didn't want to be paid by a letter of credit, and the buyer didn't want to buy from Tradex. So these two companies decided, hey, why doesn't Tradex sell the rice under Howell's name? And then the buyer will be okay with that, because the buyer just doesn't want to buy from Tradex, but the buyer will buy from Howell if he thinks he's buying from Howell. And then Tradex will take the letter of credit as payment. And so they create this arrangement to kind of trick the buyer into buying from Tradex. And the letter of credit is made in Howell's name, and Howell receives it. And then Howell goes bankrupt. And Howell's bank, who has a security interest over its accounts receivable, tries to go after this letter of credit. And the question is whether or not that's proper, because Tradex doesn't want the money from the letter of credit to go to the bank. Tradex wants that money because it sold the rice. And so that's the question before the court, is whether the bank could take this letter of credit that's in Howell's name, and the bank ultimately decides that it's not proper, that the letter of credit wasn't really Howell's, it was sort of a name, but it was really a transaction for Tradex, and it wasn't Howell's accounts receivable. In any event, I think the upshot of this case is very much like the last case that we talked about, where there was confusion over the ownership of the collateral, that one element of attachment. Value given, signed security agreement, debtor has rights in the collateral. And here, that's the question again, is does Howell own this letter of credit, or is it really Tradex's payment obligation? And so that's the question here that the court is struggling with. And it's another, I think, goes to the point that as a lawyer, you want to have your clients avoid this confusion, because it may seem expedient from a business perspective but it can lead to legal confusion that can really cost money. Okay, good. Well, that wraps up. This is just a quick 10-minute video, but that wraps up this set of problems. I sent you the set of problems for this coming week and then the next coming week as well, so you know what to work on and what we'll be doing, and I will look for your outlines, and I think this has been working well. I'll look for your outlines before class on Tuesday, and on Thursday just email them to me. That's fine. And and then I will post another video. And I don't know if this video works better. I mean, it's probably a good way to do it. I think it's a little more interactive. So I'll post another video for Tuesday's class and then Thursday, and then I'll be back in the classroom with you guys the following week. And I look forward to that. And we'll tie up any loose ends, and we can revisit the material and make sure that we're all on firm footing, and then move forward. Okay, and feel free to use the discussion group if you want to do that online, or if you have any questions, just email me, and I will respond ASAP. Okay, I hope that was all clear, and I will be appearing before you in video sometime soon. Thanks, and until later.